So how did we get here? The huge rise over the last 20 years in the number of people coming to court without counsel or perhaps with only occasional legal assistance is possibly the most significant shift in both the culture and the operations of the court system that we've seen in 100 years. Because 20 years ago, self-represented litigants were relatively unusual in the court system. Even people with limited resources did not feel that they could come to court without a lawyer. Much has changed in that time with the advent of the internet, an influx of self-help resources, and more consumer confidence about trying to do things on their own when they can't afford legal assistance. Statistics from across North America revealed that the precipitous rise in the volume of individuals coming to court without counsel began in the early 1990s. Between 1995 and 1999, the number of SRLs, or self-represented litigants, in Ontario's unified family courts rose by 500%. In North America's largest jurisdiction, California, SRLs were 46% of those appearing in family court in 1992 and 77% by the year 2000. Back in 1971, they were just 1%. While the early 1990s seems to have been the beginning of the rise in SRLs, the trend continues to be upwards. David Tavender reports that the number of SRLs appearing in Alberta family law chambers has increased by 160% since 2006. The British Columbia Court of Appeal has recently reported that 25% of civil litigants were SRLs in 2010, rising to 30% in 2014. I've been asked to take a 360-degree view of what the self-represented litigant phenomenon means for the legal profession. And in the next 15 or 20 minutes or so, I am going to try to plant some seeds by looking at this from three particular perspectives. The first is, what is the impact of the self-represented litigant phenomenon on the culture of the justice system, on its day-to-day norms and operations? Second of all, I'm going to talk a little bit about what the implications might be for lawyers in relation to their own clients, of dealing with self-represented litigants on the other side, but also experiencing their own clients sometimes coming and going as they run out of resources and attempt to do some of their own legal work themselves. And finally, I'm going to talk in a little bit more detail about the challenge that many lawyers are concerned with, which is how they comport themselves in relation to a self-represented litigant on the other side and what their duties are to their client when that is the arrangement. I'm going to start by talking about culture change in the justice system and the ways in which self-reps are affecting the changes in culture that I believe that we are seeing more and more rapidly across Canadian courts. In the 19th and 20th centuries, professions like law developed specialized training that made them the gatekeepers of knowledge. We sometimes talk about this as the expert-novice model. And that expert-novice model has obviously sustained the idea that those professional insiders would be in charge, would be in control of the norms of the justice system. The difference that we're seeing now is that more and more people can educate themselves using resources on the World Wide Web and come with an expectation of being able to handle a certain amount of their own matter. The 21st century consumer is not as willing to simply hand over to a professional person and don't have the same kind of deference for their training and expertise as they might have done 20, 30, 50 or 100 years ago. And this means that there are many things that are different about the experience of simply going to court for people who would ordinarily have expected a certain amount of deference to their authority, and they would have not expected to be meeting quite so many people who are trying to represent themselves. For the bench, they're finding more and more often that they are seeing self-represented litigants appearing before them in their courtrooms in a way that they would never have expected if they've been appointed 10, 15 or 20 years ago. I think it's fair to say this is not the gig they signed up for, and it comes with a lot of challenges. For lawyers also, when they go into the courthouse, they are not seeing the same population in there that they were used to seeing 10 or 20 years ago. there are more and more people who are there on their own, without lawyers. And this lends a very different feeling to what it's like to be in the courthouse. And we certainly know this from spending so much time there when we collected the original data for the National Study of Self-Represented Litigants. For example, self-represented litigants will be crowding outside the courtroom waiting for their appearance. They'll be anxious. They might be distressed. They won't have lawyers with them who might be able to keep them a little calmer or who will be able to speak for them. It may feel chaotic at the registry with people who are not accustomed to collecting forms, lining up, completing those forms, filing papers, standing in the registry alongside lawyers and clerks who are much more familiar with this. All in all, it feels different in the courthouses now. And the influence of people who are coming as lay people is diluting what used to be a feeling of relative calm, relative sanctity, where only those with professional knowledge and experience were associating with one another. A lot of SRLs have talked to us about feeling that when they go into the courthouse, they are somehow excluded or not fully welcomed because they don't feel that they can really be part of that inside crowd that has for so long been in control of the culture of the courtroom. Some of them have complained about feeling excluded as if from a club, because that club has rules, has vocabulary, has unwritten norms that they can't necessarily understand or access. This next clip is of a self-represented litigant who talks about the work that she did representing herself in court 4.5 years ago, and how difficult it was for her to be able to feel that she really understood those unwritten rules and could really be part of the club.
The thought that everybody who self-represents wants to because they want to challenge or they want to argue with the other party, and I'll show you in court and I'll win and I'll beat you. Well, that's just ridiculous. I don't know what the judges think. I don't know what the other lawyers think, but it's a club. It's a club that you don't belong to, and you have to try and figure out the rules, and they don't give you the rules, and they're not written out anywhere. You know, if you haven't gone to law school, if you haven't grown up in that club, there's no way you're going to figure it out. So that was my harsh reality, is trying to claw my way through a system that I knew nothing about. Even though, you know, I'm an intelligent person, it's like learning a new language or being dropped into a different culture where you don't know why people are behaving the way they're behaving or why they're doing certain things, but they're doing it. And so you got to kind of blend in. You don't want to stick out, and you have to know how to behave and what to do and when to do it. And if you don't, it could be to your detriment, you know, in a legal system, in the family law system.
Kelly now works in the justice system with SRLs in a mediation program, but she still recalls the frustration that she felt 4.5 years ago trying to operate as a self-represented litigant herself. And what she's talking about in this clip is in some ways a stereotype held by some SRLs of system insiders, that they are trying to take advantage of them, that they have knowledge that is not being shared. That is a little bit of a stereotype in the same way that judges and lawyers have stereotypes that they hold of self-represented litigants. That self-represented litigants, for example, believe that they could do better representing themselves than a lawyer could. That a self-represented litigant is just having a little bit of an adventure. I'm going to talk a bit more about these stereotypes later, but suffice to say there are stereotypes on both sides of this debate. So what would the justice system look like if it were designed for and by its users instead of structured in a way that was what worked for the insider professionals? It would be affordable, first of all. It would be understandable and accessible. It would be consistent so that people would have a reasonably good idea each time they came to court of what their experience was going to be like. And it would aim to reduce rather than escalate conflict. Now, there are many people within the justice system who would share those goals, but those are goals that at the moment we aren't able to offer for our users, and certainly goals that would be at the top of their list if they were talking about what they would like the justice system to look like for them. Let's think about how legal services might be redesigned from the perspective of the needs of users, bearing in mind those 4 priorities we've just talked about. First of all, in order to make legal services affordable, we need to promote new models of service delivery. That includes unbundled legal services, fixed fee transactions, and even shared tasking involving another professional or perhaps involving the client. These are ideas we've been talking about for a long time, and there have even been changes in professional rules to try to accommodate them. But we still rarely see these models being offered in a way that makes legal services genuinely affordable to people across the country. They need promoting by continuing legal education and through the regulators. Secondly, we need to think about moving away from the adversarial culture that we still see predominate in legal education and practice. Again, this means education, continuing legal education, but also changes in law school education and promoting a settlement and negotiation approach, making that the essence of good lawyering. And finally, we need to think about transforming the lawyer-client relationship away from the traditional model that we saw develop in the 19th and 20th centuries, where lawyers were the font of knowledge and their clients simply deferred to their expertise. As I've already said, clients these days have a different idea about their participation. They also will be looking for second opinions on Google as soon as they've talked to their lawyer, or perhaps even before they've talked to their lawyer. All of this means that the lawyer-client relationship needs to become far more of a partnership than an expert-novice relationship. Continuing legal education can help here too. But what maybe is the most important point to bear in mind when we think about the changes in justice system norms and culture that are coming about as a result of the influx of self-represented litigants is that this isn't an either-or choice. This isn't the justice system needs to stay the same way that it has been, where it is primarily determined and controlled by the professional insiders. And it doesn't mean that the justice system should be simply handed over to the users to be redesigned. It's not an either-or question. It's a much more complicated one. And that question goes something like this. How can we develop dispute resolution systems, courts, that enable public participation and choices, but still make the best use of expert agents? The second question that I want to talk about with you is implications for your client. Now, I find that the place that lawyers usually go to when they first start thinking about self-represented litigants is what it's going to be like when they have to deal with a self-represented litigant on the other side. And I am going to talk about that in a few minutes. But first of all, I think it's really important that lawyers think about what this means for their own clients. Because the clients that you have now are not necessarily going to be with you to the very end of your matter. More and more lawyers see their clients coming in and out. They hire them on, they do some work with them, they help them through the early stages, they run out of money, the clients go off on their own, they do some of their work themselves, and then perhaps they get a little more money loaned to them from somewhere, or they have a particularly nerve-wracking event coming up and they come back to their lawyer again. We've started calling these folks the on-again, off-again clients, and I think that they are part of the reality for many personal service lawyers now, especially family lawyers. And so part of what I would like to talk to you about this afternoon is what it means for you to have clients who might be sometimes on and sometimes off. And also for those clients who do stay with you all the way through, what are their needs and expectations, which are actually changing in just the same ways as we are seeing the culture change around representing yourself. So what kinds of different expectations does your 21st century client have? First of all, we've talked several times now already about their access to the World Wide Web. As one put it to me, Google is my lawyer. That information might not necessarily be as useful and applicable as a client might think it should be, But nonetheless, the expectation is there that there is this vast source of second opinions, and that makes a lot of difference, as I'm sure many of you are already aware. Secondly, 21st century clients have different expectations of value for money. Sometimes this is described as more for less. Obviously, clients have always wanted value for money, but they are going to ask more questions now. They're going to wonder whether or not they can do some of these things for themselves and reduce their bills. And in part, these questions come from a decline in professional deference generally. There's far less respect and assumption that a professional always knows best than we saw at the end of the last century. More and more need to ask questions and more expectation of being personally involved in decision making. This is in part due to the rise of a self-help culture and a personal empowerment culture, and we see this played out all the time in the ways in which clients now expect their lawyers to make decisions with their views in mind. And I'm sure that all of you listening to this are aware of those kinds of changes. So if these are the implications for lawyers' own clients of the self-represented litigant phenomenon, and really more broadly, the changes in the ways in which clients are going to be looking at lawyers and asking them to help them and expecting to be part of what they do, how does this pan out in terms of the response of an organization that is focused on providing continuing legal education? What kinds of continuing legal education opportunities and needs does it give rise to? Most of what's on this list flows directly from what we've already talked about. There's the opportunity to provide education on alternative billing arrangements and fee structures. In particular, unbundled legal services, which we hear members of the public and particular self-represented litigants asking for constantly. There's the opportunity to provide continuing legal education on lawyer-client partnerships and what it means to work with a client who no longer regards their lawyer as the unassailable expert and wants to be part of decision-making. There's the need to provide continuing legal education on the professional partnerships with others, with other disciplines that lawyers may increasingly, with the relaxation of professional rules, be able to make, and how they can work collaboratively with financial professionals, with mental health professionals, and others. There's a need for education on how to inform clients better about the choices that they might make. With alternative billing arrangements, there's going to be choices, and clients need good information that their lawyers should be able to provide to them about how to make those choices, about the extent of service, and as well what it means to do due diligence. Much of what lawyers do today, especially in the family law area, is constrained by models imposed by regulators and insurers that require certain things to be done in order to achieve due diligence. Is that something you could talk to your client about? Is that something that is going to be increasingly questioned by clients? These are also issues that could be covered in continuing legal education. At the NSRLP, one of the ideas that we have been promoting since the results of the original 2013 study is an idea of legal coaching. In other words, lawyers and others acting as coaches to self-represented litigants. This is an entirely different model of client assistance to the traditional lawyer in charge model, but it's one that we have seen growing interest in amongst different law societies and within the legal profession generally. The idea is that the client here is essentially representing themselves, but will come back to the lawyer for frequent consultations, help with preparing documents, with arguments, perhaps getting ready to go to a negotiation or a mediation, and the lawyer will act as a coach in that capacity. We believe that this is a model of legal assistance that could be both tremendously useful to self-represented litigants, and it flows directly from the data that we collected for the study. We also think that it's a model that could be economically marketable for many lawyers. So another possibility for a continuing legal education program, and this is beginning to happen in different parts of the country, would be one that looked at this idea of legal coaching, how to set it up, what would be done, and what some of the challenges might be. The third thing that I want to talk to you about today is what lawyers need to think about and what are the challenges that are raised when they're facing a self-represented litigant on the other side of their matter. This brings many complications and challenges to their role. Just like the judiciary, lawyers don't have a script or past experience often in how to deal with adjusting their practice to dealing with a layperson on the other side of their matter. And to make matters worse, at the moment, the professional codes are almost silent on this issue. I'm sure that there will be developments in this area over the coming years, but it's important to begin a conversation about what kinds of adjustments are necessary. Obviously, a lawyer's first duty is to their own client. That is where their first commitment lies. But it's just not possible to work with a layperson on the other side of the matter without making significant adjustments to practice. So one of the places that I think it's important to begin here, and this is not to say that this is all the lawyer's fault, but an important place to begin is with some of the stereotypes and some of the assumptions that many lawyers appear to hold about self-represented litigants. These are stereotypes that many self-represented litigants are painfully aware of themselves, and they do affect the way that the relationship develops, usually not in a good way. So remembering that there are stereotypes held on both sides here, let's just think for a moment about some of the data that we have that suggests that lawyers habitually hold the following types of stereotypes about the SRL that they may be facing on the other side. There are three particular stereotypes set out on this slide that don't represent every possible stereotype, but are certainly the ones that we come across the most frequently in our research. The first is that SRLs would prefer to represent themselves than to be represented by counsel. This really is a myth. When we asked people in the 2013 national study if they would prefer to be represented by counsel than to do the matter themselves, almost everybody said that they would much prefer to be represented by a competent, affordable counsel. But the problem was they couldn't afford counsel. In full, 86% of the people that we interviewed who were representing themselves were still seeking assistance, legal assistance, either at pro bono clinics or trying to find a lawyer to do some affordable legal work for them. Those that didn't were people who were in smaller courts like the small claims court and felt that they must be able to handle the matter on their own, or just assumed that any cost would outweigh the potential value of their case. On the other hand, we do see studies that show that lawyers themselves believe that self-representation is due to much more insidious reasons. For example, in a study by Nicholas Baller and Rachel Birnbaum, they found that almost 1 in 5 lawyers believe that self-representation is because of a desire to directly confront one's former partner in court. This is in family cases. That is not something that we see amongst the self-represented population themselves, but it contributes to the stereotype that self-reps are representing themselves because they think they can do the job better. Second stereotype that is commonly held is that self-reps are, to put it bluntly, crazy. And many things are called in aid to demonstrate this. One is their obsession with the details of their case, and certainly many self-represented litigants become extremely fixated on their case. It becomes extremely important to them. However, I think if we think of ourselves in the same position, we were working in an unfamiliar, intimidating environment, and the outcome of our work would determine how often we would see our children. I think we would, all of us, become a little bit fixated and a little obsessed. So that might be a pathologizing of a condition that is really just a normal reaction. And the third stereotype that we see is that self-represented litigants are unable to participate responsibly in the legal system because they're not lawyers. Now, in some ways, this stereotype is less toxic than the first two, but it's also extremely important in setting the norms that self-represented litigants currently face when they try to participate responsibly in the legal system. We found that self-represented litigants work extremely hard to get it right. The word trying, as in trying to get it right, trying to study, trying to complete my forms correctly, came up more times in our qualitative interview database than almost any other doing words. They need more assistance, and they also need more kindness if self-represented litigants are going to be more functional. To put the lie to the first of these myths, that self-represented litigants are somehow doing this to have a good time rather than out of necessity, I'm going to show you a short clip from former self-represented litigant Derek Parry, who is a church minister and is talking about what it meant for him to have to represent himself, having run out of funds to pay for a lawyer.
The idea that people want to be self-reps, well, I suppose there are always some. There will be the outliers of every population group. My experience with myself and the research that Dr. McFarlane and others have done is clear. Look, I didn't want to be representing myself. When I had to, I naively thought that I probably could. It's not true. I'm more concerned actually with the less resourced SRLs, but there's another group. They're the people who can't afford a lawyer and have no academic or other resources to be able to function as SRLs. The idea that people would really want to get into this, it damn near destroyed me, and I'm one of the strongest people you're going to meet. Sorry to be boastful, but I have resources that most people could barely imagine in terms of social support structures. I have a stable income, etc. Nobody wants to get in this by choice. If they do, then yes, they're crazy. Don't do it.
I'm now going to tell you a little bit about the data that we found in our study that would summarize common complaints that SRLs have about lawyers and common complaints that lawyers have about SRLs when they're working with them on the other side. And I would point out to you before I show you these slides that, interestingly, many of these complaints are the same. They're just the reverse one of the other. So, for example, SRLs complained about lawyers in the following ways. Counsel on the other side would not speak to them. Counsel on the other side snowed them with paperwork. And the judge pays more attention to counsel than to the SRL. When we look at common complaints from lawyers about SRLs who they're working with on the other side, they complain the SRL gets more time and attention from the judge than they do or their client does. The exact opposite of the last point on the previous slide. The SRL wastes their client's time and resources because of mismanaged documentation and processes. This is the parallel to the SRL complaint that they are snowed with paperwork that they don't understand is relevant by the lawyer. That the SRL does not know how to settle or is difficult to negotiate with. This is an interesting one because I mentioned on the previous slide that many SRLs complain that counsel won't speak to them. One of the reasons, of course, that counsel won't speak to them is because they're worried about the possibility of a negotiation taking place in the hallway to which there are no witnesses, and them being told that they did not reach the deal that they thought they did. And finally, that their own client is uncomfortable if they assist the SRL to enable an outcome. All of these are very difficult issues for counsel to deal with. There are many implications here for things that they need to talk to their own client about if they're going to be able to adjust their practice to work effectively with the other side. We all know that working with the other side is absolutely critical to getting a good outcome in any case. And so there is a lot that has to be done to educate the client of a lawyer facing a self-rep to know what kinds of adjustments might be coming up. And I'm going to speak about that in a slide in just a moment. But before we go there, I would like to reiterate that the stereotypes that I've been talking about on both sides are one of the most important first steps that can be taken within the profession to starting to deal with the consequences of the self-represented litigant phenomenon. Unless we proceed on the basis of good, accurate information about why self-represented litigants are there, what they feel about their experience, and what is motivating them, we're not going to be successful in trying to meet their needs and to adjust the modern justice system to the reality. This genie is not going back in the bottle. We have to go forward expecting self-represented litigants in our courts for many years to come. So finally, I want to say something about what kind of continuing legal education opportunities and needs there are that flow from the challenges of working with a self-represented litigant on the other side. The first thing that lawyers need to learn more about and perhaps be given some more support with is how they talk with their own client about the implications of working with a self-rep on the other side. And this might include discussing the scope and the extent of their communication with the self-represented litigant. What is probably the most challenging and is a perfect topic for continuing legal education is thinking about what kind of assistance a lawyer might offer to the self-rep on the other side that would be in your client's interests. And this is one of the most critical balancing acts that counsel has to undertake. It is obvious that many issues require communication with the other side, even if that other side is not the traditional legal counsel other side that you have generally worked with. For example, to get settlement discussions going in any way, you're going to need to communicate with the other side. How can that happen in a way that your client is comfortable with it, but will genuinely advance their interests in order that you can learn more about what the self-represented litigant needs and wants in order to be able to settle the matter? We are just beginning to see some new professional conduct codes that deal with this question, and this last slide is an example from the Advocate Society. They suggest counsel should try to communicate with and be fair with self-represented litigants. If assisting a self-represented litigant does not prejudice counsel's client, will move the case forward, and will not result in significant costs, counsel should strongly suggest providing assistance. As you move back to your discussion at your retreat, I think one of the questions that you could be considering is how proactive can the profession be here? And how proactive can the BC CLE Society be here? I've outlined many different challenges and questions, most of which are only just beginning to be talked about. There is a great deal of work to be done, and there is definitely leadership to be taken here. Thank you very much for including me in your retreat, and I hope that you found this information useful to stimulate your discussions.